When I'm talking about women and law in India, again, I'm repeating that there are two aspects. In my previous portion, I have discussed international conventions and international covenants, how they are there to protect the rights of the women, but still women are fighting for their most basic right. Now let's see that what is the condition of India. When we talk about the India can be categorically divided into two parts. The first is the post-independent India, and the second one is the pre-independent India. Firstly, I will discuss the pre-independent India, the post-independent India, where I will basically discuss different provisions of the Constitution of India. So when we talk about the Constitution of India, the Constitution of India, the idea of gender equality is very much deeply ingrained within the preamble of the Constitution. Within the preamble of the Constitution, and the preamble itself indicates that there should not be any discrimination and the right to equality should be protected. So the term equality is clearly mentioned there. Subsequently, within the Constitution, there are different provisions in Part 3 of the Indian Constitution, which are the fundamental rights of women. And the second important thing is the different directives which has been given to the state while making their policy, that how they should protect the rights of the women within the while making of the policies, while framing the policies in the favor of the women. So when I'm talking about the Constitution, Article 14 of the Constitution talks about equality. So equality also includes gender equality. So 14 Article 14 is specifically not going to mention anything about gender equality, but Article 14, which is talking about equality, simultaneously it also prohibits any kind of discrimination, and it allows positive discrimination, and it comes forward in the form of Article 15 subclause C, which says that the state can make special provisions for the women and children. So special provision for women and children itself indicates that the state has power to legislate something for the benefit of the women. Simultaneously, Article 16 says that there should not be any discrimination in the public employment. So the women cannot be discriminated once we are talking about the public employment. Right to life and dignity, that is obviously it is given to the women also under Article 21. And Article 23, it prohibits human trafficking. It prohibits human trafficking. Once we read it, I am not going to make it very much legal. Once we are going to read the directive principle of a state policy, we will come to know that under the directive principle of a state policy, there are several directions for the state which should be taken care by the state while framing their policies. And in these policies, the protection, the right of the women, it has been given a prime importance, either that is related with maternity leave, or that is related with wages, or that is related with health, or that is related with any other important aspect of women. So directive principle of a state policy and the Constitution, Part 3 of the Indian Constitution, they very clearly and categorically indicate the importance of women in the eyes of the constitution maker. And it is equally reflected once we are going to analyze the existing legislations in India. You would be surprised to know that India is the country which has the maximum number of legislations and provisions to protect the rights of the woman. There are 54 provisions and legislations which are exclusively there to protect the rights of women. And when I'm talking about there are 58 provisions which are basically going to deal with rights of the women, the important thing is what basically those provisions are. So remember, here I am going to mention something where I am saying that there are 54 provisions and legislation to protect the rights of women and girl child. But remember, this is something which is not a very celebrated thing, which should not be celebrated a lot, because more number of legislation means the society is less law abiding. Because in a law abiding society, basically we don't need law, and if there are so many laws, then there are two aspects. The first aspect is the legislature has realized the importance of legislation, and the second thing is it also indicates that society is largely failed to take up their responsibility towards women and children. So once we are going to deal with these legislations, obviously there are different kind of legislation. So you just see that how in the country like India, where the term yatra naryast pujyate tatra mante devta is used, how much it is difficult for a girl to survive in a country like India, where the women are considered as the center of the family, and without them they are considered as the backbone of the family, and without them the existence of the family cannot be imagined. But you see how and when the protection of law begins. So once a woman is pregnant, there is a first legislation which is trying to protect girl child. And why protection to girl child is required? Protection is girl child is required because nobody wants, majority, I will not say nobody, but many people do not want girl child. And it can be easily understood with the existing data that how the sex ratio between boy and girl is gradually reducing. So what is the problem? The problem is we do not want to allow a girl child to born, and that is the reason that the first legislation comes into the picture, and that is prenatal diagnostic techniques regulation and prevention of misuse act 1994. So remember, in a family, in the womb of a mother, a girl child is not safe. So law comes into the picture to give safety to get that girl child. So firstly, the sex determination should not be there. The second important thing is, if the sex has been determined and it has been find out somehow that the future child is a girl child, then the probability of abortion cannot be denied. So in that circumstances, another legislation comes into the picture, and that legislation is known as the Medical Termination of Pregnancy Act 1971. So what is the purpose of this Medical Termination of Pregnancy Act? The purpose of this Medical Termination of Pregnancy Act to stop medical termination of female fetus. So you can see that how in a country like India, where we are talking about, women is a goddess, how much difficult it is for her just to take a birth. And suppose if she has taken a birth, then what happens? Then several other legislation comes into the picture for a protection. There are several provision under the Indian Penal Code. There is POXO, which is basically dealing with prevention of sexual offenses against children. Then POXO comes into the picture to give protection to girls child, obviously to boys also, but here because I am going to deal with women, so I am basically going to take up the things which are basically going to deal with the rights of women and the girls. So then the POXO come into the picture to protect the rights of a girl child against the sexual violence. And then different provisions of the IPC, the different provision of IPC to protect her modesty, to protect her from rape, to protect her from sexual intimidation, to protect her from different kind of sexual harassments. So once she started going outside or she is within the house, how different legislations are there to protect her. So it is very much clear that a girl, either she is unborn or she is born, she is a child or she is a grown up lady, she is not safe outside the four wall of the house and within the four wall of the house. And that is the reason it is clearly proved on the basis of the above mentioned legislation which I have discussed right now. Once she started going outside and she started working, the POSH Act comes into the picture to protect her against sexual harassment at workplace. If she is going to marry, then there are several kind of legislation that protection against the domestic violence. There is a dowry legislation so that the dowry should not be demanded. If there is a divorce, then there are different kind of legislation to give her maintenance. If she is working, then equal remuneration act. To stop child marriage, there is a marriage restraint act. There are different kind of protection available to her under the Civil Rights Act, Protection of Civil Rights Act. Different kind of presumption in the favor of women under the Indian Evidence Act. And obviously these are the very positive protection, where even if the girl is going to say that she has been raped, the presumption of law is always in the favor of the girl or the prosecutrix, that whatever she is going to state, that is correct. Then there is an Indian Divorce Act, there is a Hindu Succession Act, Hindu Marriage Act, Adoption and Maintenance Act. Minimum Wages Act, Special Marriages Act. There are so many legislations which are basically going to deal with the rights of women. But here the important thing is, through the legislations or through the creation of special courts, we have institutionalized the things so much. We have made so many legislations, but why is still the women is not safe? Why is still she is fighting for her most basic fundamental rights? And to prove my point, I have given you a certain provision of the Constitution was adopted on 26 January 1950. But since the inception of the Constitution, different legislation came into the picture by the passes of time in different years. But the important thing is how the society was reacting when she was going outside or she was not going outside in the post independent India. And for that purpose, I will try to draw your attention towards some very, very important cases. And these cases reflects the psychology of the society, and up to certain extent the psychology of the judiciary also. So how the things have gradually changed. To understand this thing, I think it is very much important to discuss these few cases. So the first and the most important case is Aruna Shanbag case. Aruna Shanbag case, you all are aware. Aruna Shanbag is basically, she is a nurse in the Bombay, in a Bombay hospital, and she has been raped inside the hospital. She has been raped inside the hospital, and she lived in vegetable state for around 32 long years. But in this case, the offender, he was not punished for rape, but he was held liable only for robbery and assault. So you can imagine a nurse who is working in Bombay hospital, who was raped in 1973. She lived in vegetative state for 32 long years, and the punishment awarded to perpetrator is only for assault and robbery. So in a way, this is a clear case that how basically laws are played with words, and the victim or the prosecutrix, they don't get justice. And it also reflects the apathy, or it also indicates that how the judicial system, particularly at that point of time, they were not very much concerned about the plight of the women. So Aruna Shanbag case, it is a case which is unprecedented, and it reflects, the horrendous attitude which was shown by male counterpart who was working in the same hospital. Now the second important case is the Mathura rape case. Mathura rape case is again a very, very important case. A 16-year-old tribal girl who was raped by two policemen within the premise of the police station. So remember, the family members are standing outside. She has been raped within the four wall of police station by the police personnel. High court convicted accused. But what has happened when the matter was brought before the Supreme Court? The Supreme Court set aside the conviction of accused on the ground that there was no physical mark of injury on her body and there was no resistance on her part. So what Supreme Court is going to imagine about a 16-year-old tribal girl? According to the Supreme Court, because a 16-year-old girl, she has not screamed and there is no mark of bodily injury over her body, then why should not be presumed that whatever has happened, that was consensual? 16-year-old girl. This is another case which reflects the how the judiciary was very less sensitive about the rights of women specifically at that point of time. Then another very important case is the case of Bhauri Devi. Bhauri Devi case is a much, it is a very famous case, and it's a very, very horrible case where Bhauri Devi is a social activist and she is trying to stop, child marriage. So once she tried to stop the child marriage, she was gang raped. She was gang raped. But when the matter was brought before the court, the court has said that it is not the case of rape. So she was raped again and again and again during the judicial process. And but the Bhauri Devi case that has created a lots of hue and cry in the society, and then an NGO Vishaka comes into the picture. Vishaka files a petition before the Supreme Court and requests Supreme Court to issue certain guidelines for the protection of women at the workplace. And this was the case of Vishaka, in which the Supreme Court has given certain guidelines for the protection of the women at workplace. And these guidelines, you remember, you just see that what is the level of the sensitivity of the legislature as well, since the guidelines of the Vishaka till Nirbhaya case, these guidelines were only working. There was not a proper legislation which was enacted by the legislature. So it was a time gap of around 20 years, and in this 20 years women at several workplaces, they used to get protection only because of this guideline which was issued by the Supreme Court in the case of Vishaka. And these are the few cases. Then we have seen the case of Jessica Lal, how she was murdered, and there are 200 to 250 person who are attending that party, but each of them are going to say that we haven't seen that who has killed her. So actually, no one killed Jessica. So we can see, we have seen the case of Nirbhaya also. So we can see that from nobody raped Mathura to nobody killed Jessica, we have traveled a lot. But these are the few cases, and there are several other. There are very, very recent cases in West Bengal. There are many recent cases in Uttar Pradesh, in Madhya Pradesh, and in Andhra Pradesh also, where all the limits of cruelty has been crossed while conducting rape and while murdering these girls who were the victim of the sexual violence. So we have traveled lots of distance, and these are the certain cases which are landmark to discuss. Arushi Talwar murder cases there, which are basically related with the sexual violence and murder. But beside this, women have also faced a different kind of discrimination at their workplace, and this discrimination is not new. I have given you an example of America, and even presently, few months back, there was some agitation in some European countries for equal pay for equal work. So in the majority of the developed countries, women are still fighting for their right to equality. Right to equality, may the most basic right, which says that there should be equal wages for the equal work. In the case of India, there are legislations, but the problem is basically related with the mindset. And to prove it, I will try to mention few other cases which are very much important. I think it should be discussed here. The first case is CB Muthamma case. CB Muthamma case, the petitioner is an IPS officer, and she was denied promotion on the basis of her gender. So what UPSC chairman is going to advise her? She has been advised that she cannot join Indian Foreign Services. At the time of joining, she was required to give an undertaking that if she marries, she would resign from her services. So what is the precondition? She can join this Indian Foreign Services, but what is the precondition? The precondition is she will have to give this in writing that if she gets married, then in that circumstances she would resign. So the Supreme Court struck down this above mentioned rule on the ground that a married woman and a man, they cannot be treated differently. And very recently we have also seen the case of armed forces, where the Supreme Court has given its judgment that the women deserve for equal kind of rights in the armed forces also. So these are the latest development. But you just see the case of this Muthamma, CP Mutamma, where she has been advised to give this in writing that she would not be allowed to join the services if she gets married. Then there is another very famous case, and the famous case is the case of uh, Air India International versus Nargis Mirza. It is again a very famous case. Nargis Mirza is an air hostess. She is an air hostess, and according to the rules, she could not get married before completing 4 years of services. And if she marries, then she has to resign. And if she get married, suppose either she will give a resignation, or suppose if she get married, then in that condition she is not allowed to get pregnant, and she can serve only up to the age of 35. So Nargis Mirza case is, this is a case which we can clearly see that how the patriarchal mindset is going to treat married woman differently from a married man. And the second important thing is, in a way we can say that the motherhood, which is a fundamental right of a woman, how she is going to pay if she is going to be a mother. So this is basically in the violation of a fundamental right. This is a right to life, and this is now, according after the Putta Swami judgment, this is a also right to privacy. But then at that point of time, the Supreme Court strike down the rule related with the physical charm, and they said that you cannot put any such condition related with her marriage or related with bearing a child. That is her fundamental right, and she will have to decide this. Then another very important case, and we all are very much aware, the case of the Shah Bano case, which was decided by the Supreme Court in the year 1985. In this case, the Supreme Court held that despite of the provision of Section 127 of CRPC, which says that if a woman received an amount under the personal law, she would not be entitled to maintain under Section 125 of CRPC. A Muslim woman, according to Supreme Court, a Muslim woman would be entitled for maintenance if the amount received by her as dower was not sufficient for her subsistence. In among the Muslim in the Muslim law, Muslims still, a majority of them want to govern from their personal laws, and according to the personal law, they believe that they are not covered under the purview of CRPC. Specifically, I'm talking here about Section 125 of CRPC, which talks about maintenance. So, if whatever amount is going to give her in the form of dower, whether that is sufficient or that is not sufficient, she cannot claim any right of maintenance according to CRPC under Section 125. But in this case, in the Shah Bano case, the Supreme Court has said that she has all right to claim a right to maintenance under Section 125 of CRPC. And after that, a lots of hue and cry, and how this judgment of Supreme Court was undone by then government. That is also, we all are equally aware about that, and we are also aware that how uh, till now, triple talaq, which was discriminatory definitely, because once you are going to compare Hindu women with the Muslim women, there is a lots of discrimination. Though Constitution says that there should not be any discrimination on the basis of sex, but here there sex and religion, but here obviously there is a discrimination based upon religion and then upon the sex, because majority of them are going to claim their personal rights. In the very recent judgment of the Supreme Court, the Supreme Court has also banned triple talaq, and subsequently now there is a legislation also. So these are the certain important thing, and there is one very important case of Rupan Bajaj also. I'm mentioning this case because Rupan Bajaj is Deol Bajaj. She's an IS officer, and in this case, the name of the case is Rupandeol Bajaj versus KPS Gill. In this case, the Supreme Court has mentioned something which is very important. And what Supreme Court has said, the Supreme Court has said whether modesty has been outraged or not, it depends upon the attitude and shock which is sensed by a woman. So what basically Supreme Court is going to decide here, Supreme Court is going to decide that it does not depends upon the perception of the male counterpart, or it does not depend upon the perception of the society, but it depends upon the perception of a particular woman, that how is she is going to take a particular gesture. So if she is feeling offended, then in that circumstances, the male counterpart should be held liable for this. And then we have seen that how after the Nirbhaya case, there are so many changes in the criminal laws, and now there were very many cases of this thing, acid attack. So there are new legislation to stop this acid attack. There is new amendments in the IPC, in CRPC, and under the Indian Evidence Act to give more protection to the women. And we have seen that how through the amendment in the legislation, now the perpetrator can be awarded through capital punishment also. So these are the certain examples, these are the certain provisions, legal provisions, which basically I wanted to discuss to all of you, and they are basically going to deal with discrimination which is still prevailing in Indian society as well as in abroad. Now the important question in all these things is, if there are so many legislation, then to why the crimes are not able to control, and why they are gradually rising since 80s to the recent time. If you go and compare the data, then you will find there that there is around 875% rise in crime against women. 875. And these are, I'm specifically talking about the sexual crime. So if you forget about the rest of the things which they are going to face in their day-to-day life, like the harassment at the sexual harassment at the workplace, the discrimination which they are going to face at their home, because the home is also something which where they are not very safe. And there is a very, dangerous data according to ncrb, in 90% cases which are going to take place against the women, they are happening within the four wall of the house, and the perpetrator or the offender is the near and dear of the family. So the trust in the family is gradually diluting. So this is something which is a very, very dangerous idea, and the important thing is to understand that what is the reason here. uh, Now in the last part of my lecture, I would try to find out the solution. We have discussed a lot about the problem of the gender issues, and so much discussion is going on regarding the gender equality. But the important question is, do we understand gender equality in the correct sense? What is the meaning of gender equality? Because, yes, man and woman, they both are human beings, but there are some physical differences. Physically, the body of woman is different from a body of man, and this physical differences cannot be eliminated. That is a reality of the society. And the discrimination, or I will say the uniqueness which is vested in the woman by the nature, that is the most beautiful thing, because that is because she is a procreator. So the important question here is, I have discussed international covenants, international conventions, I have discussed Western jurisprudence, I have discussed Islamic jurisprudence, and I have also discussed the condition of women in India. And I told you that how the existence of different legislation itself proves that as a society we are failed. Now, when we are discussing the idea of the gender equality, once we are discussing the idea of equality, what do you mean by equality, and whether it is possible to attain equality at any point of time. So to know this, I think we should go back to our history, because India is the only country, if you go and check the origin of feminist jurisprudence across the world, then you will come to know about one very strange thing. And that one very strange thing is, across the globe, the feminist movement were initiated by women, but India is the only country where the feminist movement were initiated by men. And I told you that how till 20th century, in the country like United States of America, which is considered as a very advanced and very prosperous country, the women were fighting for their most basic right, like right to vote and right to property. But once you go and check the history of Indian laws, according to the Indian laws, women were never disallowed to cast their vote. Now let's go to the as I discussed in the beginning of my lecture. Now let's see what was the position in the pre-independent India. So in the pre-independent India, there are so many things which are important to be discussed here, because India is one of the oldest civilization. India is one of the oldest civilization, and this continuously sustained for such a long time period. Once you go and check the text of India, then the issue of gender equality has obviously been discussed. Presently, we believe that women are fighting for right to education and all. But once you go and check the past of this country, then in the past of this country, basically women were considered as superior in comparison to men. And I am here going to mention certain things about the Vedas, especially about the Rig Veda, because the Rig Veda is the most ancient literature recognized by the United Nations also. That is the most ancient literature. And in that most ancient literature, what kind of rights are given to the women? I'm talking about Rig Veda because once you are talking about the Hindu Marriage Act or the Hindu Succession Act, still many portions of this legislation has been adopted from Rig Veda. So what basically Rig Veda says? So once you talk about the Rig Veda, here I would like to mention one point which I think I should definitely share to all of you because that is very interesting. And that point is, across the globe in different parts of the world, there is a discussion about gender equality, but if you want to ask the answer that what is the meaning of gender equality, you will not get a clear answer. So for American, gender equality means copying each other character. So what happened in America? The women started consuming alcohol, they started believing in sexual liberty, they started consuming cigarettes, and they basically forgot this idea that they have capacity to procreate, so they are the generator of the next generation. Once you read Rig Veda, till now I did not get anywhere the definition of equality, but Rig Veda is the only source where I get a sutra or a shlok which talks about the gender equality. एंड वॉट दिस श्लोका सेज, दिस श्लोका सेज, जैसे कि मैं हिंदी में बता रही हूँ बिकॉज संस्कृत में मुझे याद नहीं है, बट मीनिंग आई एम जस्ट गोइंग टू टेल. द श्लोका इज मेंशन इन ऋग्वेदा. एंड व्हाट ऋग्वेदा सेज कि जैसे चने की दाल होती है, चने की दाल में ऊपर एक कोटिंग होती है और उस कोटिंग के अंदर चने के दो बीज पत्र होते हैं जो एक दूसरे से जुड़े होते हैं. From the outside that is one, but from the inside they are a single piece is divided into two equal part. दोनों में से ना तो कोई किसी से बड़ा है और ना ही कोई किसी से छोटा है, और अगर वो अपने आप को दूसरे से बड़ा या छोटा करने की कोशिश करेंगे तो जो दाल के दाने का अस्तित्व होता है ना, वो खत्म हो जाता है. तो Veda is saying the same thing is applicable in the case of gender equality. Neither man nor woman, nobody is superior, nobody is inferior. They both are equal and their uniqueness should be celebrated. So they don't need to copy each other, but they just need to respect the roles and dignity of each other. So this is the very beautiful definition where you can see that they are not talking about copying each other, but they are talking about respecting the status, the existence of each other, which is very very important. And once you read more provisions, more shlokas of Rig Veda, there are different shlokas, and I am discussing all these things just to put a point कि ऐसा नहीं है कि हम जेंडर इक्वलिटी को अटेन नहीं कर सकते, हम कर सकते हैं क्योंकि हमने पास्ट में किया हुआ है, और जो पास्ट में हुआ है वो फ्यूचर में हो सकता है. द ओनली थिंग इज कि वी डोंट हैव रियलाइजेशन, एंड व्हाई वी आर नॉट रियलाइजिंग द थिंग, आई विल आल्सो डिस्कस दोस थिंग्स सब्सिक्वेंटली. बट द ऋग वेदा सेज, in Rig Veda, there are sorry, in the Vedic Kal there are 23 Ved Rishikas जिन्होंने की वेदों की रचना में अपनी महत्वपूर्ण भूमिका निभाई. एंड वी आर वेरी मच अवेयर अबाउट सेवरल फेमस विमेन एजुकेटर. मैत्रेयी हैं आपकी, अपाला हैं, घोषा हैं, देयर आर मेनी नेम्स. तो 23 वेद ऋषिकाएं थी जिन्होंने वेदों को लिखने में महत्वपूर्ण भूमिका निभाई. व्हाट ऋग्वेदा सेज अ वुमन हैज राइट टू रिमेन अनमैरिड. अगर वो शादी नहीं करना चाहती देन शी शुड नॉट बी फोर्स टू गेट मैरी, और अगर वो अनमैरिड रहती है देन इन दैट सर्कमस्टेंसेस शी वुड बी एंटाइटल्ड टू गेट अ शेयर इन द प्रॉपर्टी ऑफ हर फादर. If she gets married, then in that circumstances her place should be the superior most in the family because she is the center of the family. तो उस condition में after the marriage she would be entitled to get share in the property of her husband. And even if she gets if she gets widow, then too she has all right in the property of the husband and she should be respected equally. She must have all the right to get education and she must have all the right to choose her life partner. That's why we have seen कि स्वयंवर की जो प्रथा थी वो हमारे यहाँ पे 12वीं 13वीं शताब्दी तक दिखाई देती है, जहाँ पे women never used to force to get into a particular matrimonial relationship. तो उस इसका मतलब ये है कि हमारे यहाँ पे अगर आप भारतीय सभ्यता को देखिए, मैं सभ्यता यहाँ पे इसलिए स्पेसिफिकली यूज कर रही हूँ बिकॉज आई जस्ट मेंशन दैट इंडिया इज द ओनली country where the feminist movement was initiated by men. So why it is so? Why it is not in the rest of the world? Because India has seen that condition. India has seen that past. We can take the example of Rani Lakshmibai. Her leadership was not challenged by anyone. She was accepted by everyone. We can take the example of Jijabai. Then there Durgavati, and there are Begum Hazrat Mahal. There are many names, and these names were happily accepted by the male counterpart, and they never realized any kind of gender discrimination, and they claimed all these things. They got all these rights because they deserved. सो इफ दे डिजर्व देर इज नो रिस्ट्रिक्शन ऑन द पार्ट ऑफ द सोसाइटी. और यहाँ पे एक बड़ी इंपॉर्टेंट चीज ये होती है कि द क्राइम अगेंस्ट वुमेन, स्पेशली द सेक्सुअल वायलेंस अगेंस्ट वुमेन, दैट वाज ऑलवेज कंसीडर्ड एज द मोस्ट हीनियस एक्ट. सो आइदर यू रीड चाणक्य's अर्थशास्त्र, you read Manusmriti, or I am here just going to quote one chopai of Ramayana, because in the case of Ramayana, this is also very important to understand. When Bhagwan Ram killed Bali, Bali is saying कि I am so much a powerful person. अगर आपने सुग्रीव की जगह मेरा साथ दिया होता तो मैं आपको युद्ध में कहीं ज्यादा फायदा पहुंचाया होता, तो आपने मुझे क्यों मारा, मुझे मार करके आपको क्या मिला? Then what Rama is saying, and I am mentioning here because this is something which is basically related with feminist jurisprudence. So what Rama is saying, अनुज वधु भगिनी सुत नारी, सुनु सब कन्या सम अचारी, इन्हें कुदृष्ट बिलो के जोई, ताहि बहो बधे कुछ पाप न होई. यानी कि भाई की पत्नी को, बहन को और बेटे की पत्नी को, इनको पुत्रीवत माना जाना चाहिए, और जो भी इनको कुदृष्टि से देखे उसका वध करने में कोई भी नुकसान नहीं है. दिस इज एन एग्जाम्पल विच इंडिकेट्स दैट व्हाट इज द what basically, because Lord Ram is considered as Maryada Purushottam. So what is his statement about against any kind of crime which is basically related with women? So that is his point of view, and it reflects that because Ram is the ideal for society, so it very much reflects that Rama is saying that the women should be respected. And then subsequently, even in the Mahabharata, in Mahabharata, there are several issues. Like once you read the Mahabharata, in case of Mahabharata, at one point of time when the war is over and Yudhishthira approached to Bhishma Pitama, to take some education about the political science, that how to rule. And what Bhishma is going to say, what Bhishma is going to tell to Yudhishthira. भीष्म ने ये बोला युधिष्ठिर से कि जिस समाज में, परिवार में या देश में स्त्री का सम्मान नहीं होता, वो समाज, परिवार और देश नष्ट हो जाता है. So the women should receive respect in every case. Of the family system, that the women should be respected. Now यहाँ पे important चीज ये होती है कि why, even if there are so many legislations, why we are not able to control crime against women? The problem is we are not realizing that where the problem exists. Once we are going to talk about the society and the law, there is a big difference. Once we talk about the old India, before the arrival of the Britishers, or before the Britishers enacted their laws for the Indians, India was a morality driven society. So at that point of time, we did not institutionalize morality very much. It used to be driven by the society. That's why there is a very famous shloka, and the shloka says, Narajyam na raja sinto dando na cha dandika धर्मेण एव प्रजा सर्व रक्षन्ति स्म परस्परम. अर्थात न तो राजा है, न दंड व्यवस्था है, न राज्य है, न किसी को दंड दिया जाता है. लोग परस्पर एक दूसरे के हितों का सम्मान करते हैं और उनकी रक्षा करते हैं. सो दिस श्लोका इज बेसिकली टॉकिंग अबाउट अ ड्यूटी ड्रिवन सोसाइटी which is indicating that we all should follow our duty towards others. And once we are a duty bound society, the first and the most important thing is we will respect dignity and right to life of others. So when India was not a very much institutionalized society, at that point of time the society was driven by morality. Now what is the problem is we are saying that law is a morality, but the morality has become secondary, and primarily we are going to focus on legislations. And legislation basically it depends upon the implementation. So once there is a legislation, should be an institution to implement those legislation also. So the entire process is going to becoming very cumbersome. The most important thing is, if we want to develop the sense of gender equality, we should develop this sense in each and everyone, that there is no difference between two human beings. We should be a duty oriented person, and to realize it, there is very much required a kind of spiritual evolution. This is a very important thing, because why the crime were not there at the time of during the Vedic period, because at that point of time meditation was a very essential part. The society of India was the spirituality driven society. And once I'm talking about the spirituality driven society, believe me, I'm not talking about religion. Spirituality means how you are going to evolve yourself. So once, because India is a country of spiritual democracy, this is the land of spirituality. And once I'm still, this is the land of spirituality. And when I'm talking about the spiritual evolution, the meaning of spiritual evolution is you are going to expand yourself. And when you are going to expand yourself, it is not about the physical expansion, but it is all about the expansion of your consciousness. So once you are going to expand your consciousness, you will find no difference and no discrimination between you and others. So according to the spirituality, we all aham brahmasmi, and we all are the manifestation of God. So my pain and pleasure are very much like the pain and pleasure of others. So what I do not like, जो मुझे अपने साथ होता हुआ अच्छा नहीं लगता, वो मुझे दूसरों के साथ नहीं करना चाहिए. So a spiritually elevated soul does not believe only in physical existence, but she can see but a spiritually enlightened person can go beyond the physical existence. But what is the problem? The problem is, by the passes of time, this spiritual aspect, which was the very essential part of our education system, we left that. And once we left the idea of spirituality, now we are religious, but we are not spiritual, because a spiritually enlightened society never believes in any kind of discrimination. Now we want to run everything through the hunter of institutions. So it is becoming very very difficult. We are from a conscious soul to a physical body. If we are moving towards a physical body, then we are going to identify bodies on the basis of their gender. And once we are going to identify bodies on the basis of their gender, then in that circumstances there is a feeling of gender dominance and gender discrimination also, and that is the main problem. So the spiritual evolution, and this is something which has been now globally recognized, because once you go and check, earlier there was a lots of emphasis upon the IQ, yani intellectual quotient, but subsequently they started talking about emotional quotient. Now they are also talking about the spiritual quotient, because world has seen that the way, the direction in which they are moving, and there's so much institutionalization and so much mechanization, using of so much of artificial intelligence, it is converting a man into a machine. And once a man is going to convert into a machine, he is definitely going to lose the value of his emotions also. So we are going to create an emotionless society, where the people have no respect about the pain and pleasure for other. And that is the biggest problem, because whoever is in the dominating position, they want to suppress other. And that is the biggest reason, that despite of having thousands of legislation, thousands of provisions, thousands of police personnel, many international conventions, still we are not able to control crime against women. I have given you the example of United States of America. Is still the percentage of sexual violence against women is highest in America, highest, and many of them are still unreported. So why these things are happening? These things are happening because we are believing so much in our bodily or physical existence, and we are so much aware about our physical satisfaction, but we are not aware about our spiritual existence. So that is something which is very much important, is how to enhance the spiritual quotient of the society, how to give them moral education, how instead of institutionalizing the law, why it is more important to institutionalize the morality. These things should be discussed right now, if actually in the true sense we want to develop a society where the people respect each other's right. So obviously, the women, discrimination against women or the crime against women, this is a social problem. Solution is not only in legislations. The women are still fighting for their most fundamental right across the world. Still, after so many legislation, crime against women is rising in India. And the problem we have discussed, and now I am discussing the solution. The solution is basically is in the self realization. Solution is basically in teaching the moral or ethical values. Unless and until we are going to sensitize people about the moral values, we are going to sensitize people about their past, we cannot attain a society where women are not discriminated. So with this, I am just going to close my lecture, that gender sensitization and value based society is very much required, and it should be started within the family, and then from the school, and then up to the age of 15 and 16 there should be a proper moral education for each and every children. Spirituality or meditation, it should be made an essential part of, is essential part of course curriculum. Then in that circumstances, I think 10 years or 15 years down the line, we would be able to create a society where the women right will be more respected, because now the technology has created another problem. The pornographic content is very easily available to all these young children or to anybody, and that is also adding the number of crimes against women. So challenges are many. The most and the best solution is the self control. So self control or self regulation is possible only in the case of self realization, and self realization is possible only through spiritualization. So spiritualization takes you from bodily feeling to, the feeling of unanimity, the feeling of oneness. And the lack of spirituality brings you from oneness to the feeling of differences. So with this, I would like to close my lecture, and I give big thanks to the organizer for providing me this opportunity. Thank you so much. Thank you.